The Voting Rights Act, a cornerstone of American democracy, is facing its most significant threats in its 60-year history. The law, enacted in 1965, was designed to end the hypocrisy of a democratic country that denied Black people the power of their vote. However, 6 decades later, the act remains at the forefront of the political battlefield. With cases before the U.S. Supreme Court and a platoon of Texas legislators fleeing the state to prevent redistricting, the struggle for civil rights has been a long and arduous one, with the passage of the Voting Rights Act marking a revolutionary turning point in American history. The law fundamentally rewrote politics in America, forcing jurisdictions with a history of discrimination to clear elections changes with the Department of Justice before they could go into effect. It also banned literacy tests to vote and allowed challenges to district maps when those maps would not allow proportional representation for minority voters. Despite the progress made, the Voting Rights Act has suffered a series of setbacks in recent years. The Shelby County v. Holder case of 2013, which held that the data defining jurisdictions with a history of discrimination was too old to be relied upon, effectively ended pre-clearance. The 5-4 decision in Rucho v. Common Cause in 2019 further eroded the power of the Voting Rights Act, permitting political gerrymandering while racial gerrymandering remained off-limits. The mid-decade redistricting in Texas proposed by Donald Trump presents a vivid example of the consequences of an end to pre-clearance and recent Supreme Court decisions. Democratic state representatives have fled the state to deny Republicans a quorum to pass the redistricting legislation, which would likely grant Republicans an additional 5 congressional seats in Texas by concentrating some minority voters into fewer districts while diluting clusters of other voters. The Department of Justice's Voting Rights Division, which used to have about 30 staff attorneys, has lost all but 2 or 3 under the Trump administration. This has raised concerns about the ability of the Department of Justice to enforce voting rights. As Jacqueline De Leon, senior staff attorney with the Native American Rights Fund, noted, "We know the Department of Justice is not going to be in the business of enforcing voting rights." A case in Louisiana that has reached the U.S. Supreme Court threatens the last leg standing of the Voting Rights Act. The case, Louisiana v. Callis, asks whether the state's creation of a majority-minority congressional district violates the 14th or 15th Amendment to the Constitution. Sophia Lin Lakin, director of the ACLU's Voting Rights Project, expects the Eighth Circuit ruling to be appealed to the Supreme Court. The Voting Rights Act has been a cornerstone of American democracy, ensuring that the voting power of racial minorities has fair representation. However, the recent attacks on the act have raised concerns about the future of voting rights in America. As Lakin noted, this is, unfortunately, another opportunity for the court to continue to attack this pillar of our democracy, the Voting Rights Act. The struggle for civil rights is far from over, and the Voting Rights Act remains a crucial tool in the fight for equality. As Todd Cox, Associate Director Counsel for the NAACP Legal Defense Fund, noted, democracy is at stake. The fate of the Voting Rights Act hangs in the balance, and it remains to be seen whether the law will continue to protect the voting rights of minority voters. The controversy surrounding the Voting Rights Act raises important questions about the role of the Department of Justice in enforcing voting rights and the impact of recent Supreme Court decisions on the act. As the Supreme Court considers the constitutionality of Section 2 of the Voting Rights Act, it is clear that the fate of the law hangs in the balance. Will the Supreme Court continue to chip away at the Voting Rights Act, or will it uphold the law as a properly constitutionally authorized use of Congress's powers? Only time will tell. In the meantime, it is essential to reflect on the significance of the Voting Rights Act and its impact on American democracy. The law has been a cornerstone of civil rights, ensuring that the voting power of racial minorities has fair representation. As the country moves forward, it is crucial to consider the importance of protecting voting rights and the role of the Voting Rights Act in achieving this goal. The struggle for civil rights is far from over, and the Voting Rights Act remains a crucial tool in the fight for equality. As the Supreme Court considers the constitutionality of Section 2 of the Voting Rights Act, It is clear that the fate of the law hangs in the balance. Will the Supreme Court continue to chip away at the Voting Rights Act, or will it uphold the law as a properly, constitutionally authorized use of Congress's powers? The answer to this question will have significant implications for the future of voting rights in America. What do you think about the current state of the Voting Rights Act? Do you believe that the law is still necessary to protect the voting rights of minority voters? Or do you think that it has outlived its usefulness? Share your thoughts in the comments below.